Good day. Thank you for joining us for our annual webinar series with Conexxus. And today we're especially pleased to have Todd McClelland, who is a partner with McDermott, Will & Emery, to talk about breach response considerations for the convenience store market and petroleum market. Next slide.
Well, let's see here. Let's try another one.
Thanks, Todd.
There we go.
So just quickly, our agenda today, I'll go through a couple of housekeeping items and talk a little bit more about Todd and about Conexxus. And then we'll have our presentation, and then we'll go through some questions and answers. Next slide. Our host today with Conexxus is Allie Russell, and she's a standards coordinator. And myself, I'm Cara Gunderson. I'm the chair of the Data Security Committee. By day, I am the point of sale manager with Citgo Petroleum. And we are very excited to have Todd McClelland, who is a partner, as I mentioned, with McDermott, Will & Emery. And Todd is an attorney that specializes in cybersecurity and cyber law. And Todd, why don't you tell us a little bit about yourself?
Yeah, thank you, Cara. Thank you for the kind introduction. I've been practicing for a little over 20 years. My practice is really kind of three parts. It's breach response, privacy and cybersecurity compliance, and then technology licensing, which those three, as you might imagine, overlap increasingly and on a great deal. So, of course, what we're going to talk about today is the breach response, but I'll throw in some of the relevant aspects of those other areas of my practice during the course of this discussion.
Thanks, Todd. Okay, next slide. So Conexxus is an independent, nonprofit, very member-driven technology organization. So like, for instance, I'm a volunteer for Conexxus. Todd is a volunteer for Conexxus. And as I said, standards, again, they take the subject matter experts and those that are very interested in studying that technology standard and security, mobile commerce, and group together to perform and create these standards that we see throughout the petroleum industry. And it's especially advantageous for all stakeholders because of the fact that we don't have to create individual standards by each merchant, by each point of sale vendor, fuel dispenser manufacturer, loyalty, back office. All the stakeholders can use those standards, and that saves us all a lot of time and a lot of money. So Conexxus is also an advocate for the industry, and you see them involved in many organizations, you know, and I like to think of them as sort of as the technology arm for NACS, as they provide vision, help identify emerging technology and trends, and like I've mentioned, really, really an advocate for our industry and helping us develop technology for policies. Next slide. We've had a great webinar scheduled so far this year, and today, obviously, we have Todd, and then next month we have how an attacker bypasses the network, software, and physical controls by a couple of subject matter experts. In July, we will have Troy Leach from the PCI Security Standards Council telling us a little bit about the insights, and we'll get a little sneak peek behind the curtain of PCI DSS 4.0. Next slide. And as you can see, we've got some great webinars coming in for the remainder of 2020 as well. Next slide. And I'd like to thank our 2020 Diamond sponsors for Conexxus, and they are a big reason why Conexxus can continue to exist and provide you with all of these great technology resources. And I would like to mention that this webinar is being recorded. And so we do ask that you ask questions via the question panel in the GoToWebinar panel. And we will, as I mentioned earlier, have a question and answer session at the end. And please note specific vendor questions. And then the last thing to remind you before we get started here is the fact that we will have the presentation available to you. And so about an hour after the webinar concludes, you will receive an email with a survey link. I promise the survey is super short. It was kind of like, how do you like it? And then what you'd like to see for future webinars. And then upon completion of the survey, then shortly after that, then you will receive another link with the presentation. And of course, it's always posted in about 7 days in the Conexxus subscription of YouTube, or you can also go to the Conexxus website, which is conexxus.org, and it's under resources under webinars. So with that, I'm going to turn this over to Todd. And Todd, thanks again for sharing all of your wisdom. And we know that you've seen a lot of things as you've practiced law over the years.
Well, Cara, thank you for that introduction. Again, so as I've been practicing and doing breach response for a number of years now, and we've seen, and I've advised clients on breaches in a variety of different industry segments, including petro and convenience stores. And, lately, certainly COVID is slowing down commerce, but it's not slowing down e-crime or other kind of hacking activity. And as it relates to this market segment in particular, there's 4 various ways that we're most often seeing companies becoming aware they've got an issue. They've been compromised or under attack or whatnot. We're still seeing a lot of FBI notices, CPPs, common point of purchase. Namely, we're seeing a lot of suspected criminal activity involving payment card data, involving your stores or locations. Ransomware has increased by orders of magnitude over the last few months. I've got a couple I'm actually dealing with right now. We're seeing new malware variants, new attack methods. We're increasingly seeing threats of data exfiltration. In other words, not only have we encrypted your systems, but we've also stolen your data. That adds new dynamics from a breach notification perspective that makes these response efforts more challenging. We're still seeing customer complaints. Someone calls up your call center and says, hey, someone's, I only use my card at your location, or you're one of the only ones you're where I primarily use it, and someone seems to be charging my credit card. We think it's you. And then, of course, the last, and we always see these, but it's just the state-up IOCs, unusual activity on the network, activity occurring in the middle of the night when no one should be actively using a certain system on your network, or just other things that get caught up by antivirus or EDR or whatever your solution and controls might be. So these are the 4 that I'm primarily seeing. I'm sure others may have different perspectives, but this is how we're typically seeing incidents coming in the door. Now, of course, how you initially respond is everything. And what kind of lawyer would I be if I didn't say the first thing you should be thinking about is to get your lawyers engaged. They can help you in big ways. And I'm going to talk about what is the role of a lawyer in a breach in a few seconds. But certainly making sure that you've reviewed your plan, you know who to internally escalate this to, you've got your team, your CSERT, whatever you call it, ready to go. These are all critical initial action items that you need to have in mind, because making sure this escalates to the right levels, the right people are making decisions and advise, really will steer this in the right direction or off the cliff. Insurance is increasingly a common thing in breach. A lot of companies increasingly are carrying cyber liability policies, and your coverage and the amount or the degree of protection you get could be contingent upon how soon you put the carrier on notice. So make sure you're working with whoever your risk management or insurance people are early on to consider at what point you do put them on notice that you have some kind of an incident or suspect that you have one. You want to consider evidence preservation. So log overwrites, server images, workstations, securing mobile devices, all of that. You early on want to be considering it. I mean, obviously, your initial thoughts are containment remediation. But in the back of your mind, make sure that you're not overwriting logs and other forensic artifacts that could be useful in the investigation or maybe any subsequent kind of legal action or investigation. So that should be an early consideration. You want to identify your initial notification requirements. We're going to spend a few minutes later on talking about what some of those notification requirements might be. And of course, one of the early considerations is who knows? Is this known by our customers and consumers? Is it known by regulators? For example, if the FBI issued a CCP and said, hey, we think you may have had an incident, it depends on what the nature of the incident is, how you came about to know it. But the initial consideration is it public? Because that's going to greatly influence how you proceed with your investigation response and your efforts. So what is the role of a lawyer? When I get engaged by my clients to assist with a breach response, what does a lawyer do? I don't know that a lot of people really know. One of the first things we can do is help conduct a privileged investigation. And I'm going to talk about the attorney-client privilege and work product doctrine in the next slide or two. But these can be very helpful, especially later on if you have lawsuits or investigations, kind of shield a lot of those early communications that you have about the investigation. And as I'll say it again later, of course, but we cannot protect the facts. We absolutely, those are things that are going to be discoverable. We cannot shield those, but we can be very helpful in protecting a lot of those communications you have internally with your forensics people and others. And that can be very critically important in later litigation and investigations. Notifications. The United States finally now has, all 50 states have their breach notification requirements. They all vary. We know those laws inside out. We can tell you at what point during an investigation you have triggered a potential state level notification obligation. We also are very familiar with the payment brand requirements in terms of when you have to notify those. You may have other contracting parties, vendors, service providers, others who you may have to notify. All of that, the whole notification process needs to be very carefully coordinated, and that's one thing we do, and that's what we do very well. Communications, you may want to engage your corporate HR, communications people, PR. We also have a role in that because what you say publicly and internally can have an impact on your litigation stance and internal investigations. But being involved in communications early on, sending out the right message, a consistent message, those are all very important parts of an effective breach response. Law enforcement, you may choose to reach out to law enforcement. That can help you with your communications. The FBI we're seeing increasingly helpful actually with breach response. They give good IOS indicators of compromise and malware signatures that can help and aid with breach notification. And some of the new ransomware variants, for example, they've been very helpful in showing us some IOCs, what kind of software they're using, are they living off the land, what are they doing? And so we're increasingly seeing them being helpful. There can be some challenges with notifying law enforcement. There's a bit of if you're familiar with the parable of the scorpion and the frog, there's a bit of that going on. So you have to be careful with what you share with them, but they can be helpful, and that's an early consideration. I've already mentioned insurance recovery. We help, sometimes carriers don't want to pay. So we want to make sure that we tell them what they need to know at the right time, in the right way, to put ourselves in the best position to be able to successfully recover from insurance carriers. Investigations, we regularly interact with the FTC, who's a U.S. government agency that frequently looks into breaches, including as it affects this industry. Also state attorneys general and other third parties. So that's something you're going to want a lawyer to help you with because that's what we do. And then last is litigation. There is almost a knee-jerk reaction by the plaintiff's bar. They are bored with asbestos. I would be too. So now they're going after the sexier area of cybersecurity and breach response. And for some attorneys, this is becoming a very lucrative area. There's a well-known plaintiff's attorney who has a beautiful Gulfstream jet he's gotten suing companies who have breaches. So, lawyers litigate, and that's obviously something you want to keep in mind, and that's why you want to have a lawyer involved early on. One of the things I mentioned was the privileged investigation. A lot of people, it's a somewhat complicated protection. There are actually two protections we can avail ourselves here. One is the attorney-client privilege. The other is the work product doctrine. At its essence, the attorney-client privilege protects the confidentiality. It protects the confidentiality of communications between lawyers and their clients. If I'm advising you and you tell me something, that communication may be subject to the attorney-client privilege. It allows you to have a more forthcoming and honest communication with me. The privilege extends to those that a law firm engages to help advise the client. So if I engage a third-party cybersecurity forensics firm to help me advise you, the client who's incurring the breach, the communications with that forensics firm between me and them would be privileged. It can also extend to others. So if you tell me things, those might be privileged. So it has potentially widespread application. There are a lot of limitations we'll get into in a second, but that's the potential extent of the attorney-client privilege. The work product doctrine is different. It protects things that are documents, materials that are prepared in anticipation of litigation. So when we have a breach, if we expect there might be some litigation arising, which is increasingly occurring, the things that I protect or have the things that I produce or have produced for me may be subject to this work product doctrine protection. The ultimate issue is what we want to protect versus what we can protect, and those may vary, and we'll walk through that here in a second. One of the biggest issues we have with privilege and work product doctrine is waiving those protections, and it's going to be deliberate or inadvertent. As we start to get work product, maybe a forensics report from our cybersecurity forensics vendor or other things of that nature, one of the things we have to be concerned with is what happens if we disclose the documents or the contents of those documents, so conclusions that we reach, if we share it with insurance, law enforcement, the brands, and we'll talk about PFI investigations in a second, regulators, contract parties, our vendors, our marketers, and other partners we have, information sharing and analysis centers or other kind of information sharing analysis groups or threat intel groups or things of that nature, or sometimes even internally, if we share things with people who really don't need it or shouldn't have it, that too can create a waiver situation. So we have these protections. We need to be mindful that these documents we create, and the most one at risk usually is our forensic reports or things like that. If we share those things with the wrong parties or for reasons that are not related to providing legal advice or in connection with litigation, it can operate to defeat those protections. So if you work with counsel and they're constantly on you about limiting disclosures, this is why. They're worried about waiving those protections that we're trying to put in place. Just some more things about this real quick. It doesn't protect facts. I mentioned this before. So the IOCs we see, the indicators of compromise we see in our network, the fact that there's a phishing email or what the phishing email was, the Bitcoin ransom, or any other things that we discover of a factual nature, I can put those in whatever document I want, but at the end of the day, I can't protect those things. Those are facts. We can't protect facts. It also doesn't apply to things that are more business functions in nature, and a common one is PR. What I write in a press release and then put out into the public, I can't protect that. Or other things that are, a judge determines that's really not really a legal function. That's not really providing legal advice. It's more business in nature. We can't protect those. One thing to know is the attorney-client privilege has been around for years, but as it's been applied to the cybersecurity context, it is still in a very infant stage. There's not a lot of law out there as the attorney-client privilege applies to cyber and breaches and response. So we're going on a lot of just established law in other areas and coming up with this. There are a few cases out there, but these are the things that most commonly are the issue: trying to protect facts, trying to protect things that are really more of a business function. And related to this, of course, you can't just counsel me or your in-house attorney on everything and assume those communications are now privileged. If they are in connection with enabling counsel to provide legal advice, yeah, they might be. But otherwise, just copying counsel is not going to be enough for those to be protectable. Also, when it comes to engaging a forensics firm, this is a very common issue. Sometimes a company already has a forensics firm engaged, and then they bring in the counsel. In order for the work of the forensics firm to be protectable, counsel's got to lead them. They've got to be, and it can't just be a mere fiction. The counsel actually has to lead the investigators and instruct them on what to do. There can be some cooperation and collaboration between forensics and in-house IT folks and whatnot, but the counsel actually has to be leading that investigation. And if they don't, that's where the privilege gets put at risk. Counsel should be engaged by counsel. You want to limit your disclosures of findings, conclusions, protected communications, because that could operate as a waiver. Really, this whole topic is deserving a longer conversation, but I wanted to give you guys kind of an intro to the privilege. Many of you are probably, I'm sure, familiar with it already, and some of the rationale why you may see lawyers pushing back on efforts to disclose the information or documents that get produced. Cara, I'm going to pause there. Any questions from you, or you'd like to add in on that?
No, I think you're doing a great job. I think one of the things where I think it gets a little sticky is that client privilege and what is considered under privilege and what is not, and waiving that. And so I really encourage you to, before you send anything out, is to maybe even pick up the phone and talk to your attorney and just ask them how to handle it.
That's a great thought, and certainly talking over the phone can be greatly preferred than putting things in emails and written statements, because we are trying to minimize a lot of the footprint we're creating in connection with an investigation. But to Cara's great point, reach out to counsel, ask them, I want to do X, I want a person to do Y, I want to give another person Z. Can I do that? Is that going to be a privilege issue? So those are great thoughts, Cara. So let's switch gears. Let's now talk about notification. The first one, you should in any kind of impact where it's affecting, or any kind of breach that's affecting cardholder data or your CDE, your cardholder data environment, we need to be immediately mindful of, do we have an obligation to notify the payment brands? And we're going to dive into that. I'm going to show you some examples of what those requirements look like. Now, other things that you want to be thinking about, in addition to notifying the brands, is, do you have a legal notice obligation to consumers and regulators? I mentioned at the beginning that there are some 50 different laws out there at the state level that impose upon companies certain obligations to make disclosures, whether it's to state level regulators, to consumers, or others. So you need to be immediately mindful of those. Those typically, so far, don't have the same short fuse you're going to be thinking about in connection with a brand level notification, but they're out there, and you need to stay on top of those, because if you don't timely notify, regulators can and will go after you for that. It's usually a fine or something like that. So you want to be mindful of those, and your counsel should as well. You also may have a variety of different contractual obligations, and this really requires, I'd say for many organizations, it is a challenge to get on top of and to know what all of your contractual obligations are that are out there. Some of them are sneaky. Even in an NDA, you may see in an NDA a provision that says, hey, if there's a breach of confidentiality of the data, you're going to notify us immediately. And those have been used for years. That used to be perceived as a relatively benign contractual provision. But when you interpret a breach of confidentiality from a breach perspective, well, that changes the dynamics and what that timing requirement might be, or even that you have it. So, things to be thinking about. What does your processor acquirer contract say? It probably, I'm almost confident, has some form of a notification obligation to them. Depending upon where the breach is, who has notified whom, the franchisor, franchisee, marketer, et cetera. So be mindful of those. And of course, you may even have obligations to notify, if you're the merchant, your service providers or vendors. So be thinking about that as well. Now, law enforcement is a tricky one. I mentioned that parable a second ago of the frog and the scorpion. Just, you help them, they turn around and sting you. So you want to be thinking about a notification that law enforcement, not mandatory, but to be thinking about it, because they can help you, and they could be a good resource. And from a PR perspective, it's helpful, or it's generally a good practice to be able to say in any kind of a press release, we're working with or we're collaborating with law enforcement. So let's talk about PCI notifications. The first thing to note is these change, and they change seemingly once a year, sometimes more frequently. I don't know the exact frequency, but they change often, and you can't assume that what you saw the last go round or the last time you looked at these various requirements, that those are still the requirements in place. They change. You need to be on top of them, and if you have an incident, look at the most recent example would apply. So just be on top of that. As I mentioned a second ago, also your processor acquired contract likely also has requirements. The triggers for notification vary across even the requirements among Visa, MasterCard, Amex, and Discover. Some are, trigger a notification obligation upon access to cardholder data. And I'm overly simplifying here, by the way. So, you'll want to look at the full requirements to capture all the different activities that may trigger a notification obligation. But generally, access to cardholder data, access to payment systems, if there is manipulation of account data controls, a nice vague standard, or access to encryption keys. So those are kind of an overly simplified capture of what these four brands require. And like I said, if you have a breach tomorrow, go look at this again. These might change for all we know. But these are the general triggers that we see. Now, what about—
Hey, Todd, I'm sorry to interrupt. We had a question that came through regarding the notifications and, and overall sort of who's liable for what. And the question is do you see companies moving more software and systems to be managed by vendors so that they can shift some of that liability?
That is a fantastic— yes, short answer, yes. We see a lot of people outsourcing their CDE because let someone else who is already, proficient or skilled and, they've got the necessary PCI certifications, let them take this on. Now, in terms of notification obligations, this can get tricky. If you are still the merchant of record, or if you still have the contractual obligation to your processor or acquirer, you may still, notwithstanding the fact that it's your service provider who incurred the breach, you may still have a notification obligation. Now, also, they may have a notification obligation under, if they're a certified service provider, they may too have a notification obligation. And then when we think about it from a state level, in terms of state breach notification laws, there it's increasingly getting funny. It used to be the rule that the controller or the owner of the data, whoever that may be, is the one who has the obligation. But increasingly, we're seeing requirements on anyone who holds the data may also have an independent notification obligation. And that seems to be a trend in terms of amendments and updates to these notification laws. So it may be that you have the obligation. It may be that the service provider also has a notification obligation. The better practice at this point is to talk with your service provider before you have an incident, preferably at the pre-contract stage, and figure out, how are we going to handle that? Are you going to notify MI? The service provider may say, well, we may have to notify if you don't. Have a conversation, try to address that before the incident.
Thanks, Todd. Yeah, and you could actually dovetail that into your PCI requirements 12.8 and 12.9, which is the agreement between the merchant and the service providers, correct?
Excellent thought. Yep.
Okay, thank you.
Just to give you an example, we'll go through this quick because in terms of the visa requirements, and these are at least as of October 2019. This is found in their document called "What to Do If Compromised." This is a straight lift of the language. An entity that suspects or confirms an unauthorized access. So notice that it's the suspicion of unauthorized access to Visa payment account data, or, so this is triggering both the data or the system, or to any payment system that stores, processes, or transmits Visa payment account data, is required to ensure that the event is reported to, and this is an obligation to report directly to Visa, not just your payment requirer, but you have an obligation directly to report it to Visa. And note the timing here, within 3 calendar days. Those who are enduring or have endured GDPR, this will seem like a familiar time requirement. But when you think about it, 3 days after you first become aware of an incident that meets this threshold, you've got to be telling them. And you've got to tell them, let me go to the next slide. In addition to that, you also have to provide more information about it, and there's an ongoing obligation to continue to notify them about the incident. And they will follow up and inquire. You should count on that during this process. So within 3 days of notifying them, you got to provide them, and there's this attachment A attached to the What to Do If Compromised document, but it's basically an incident report. Similarly, and this is in MasterCard requirements, there are security rules and procedures. And this is a document, the version I was looking at was the February 14th version. And here they have an obligation with 24 hours. That's even shorter than the 3 calendar days. And on an ongoing basis, you got to submit to them all known or suspected facts concerning one of these events. So, the point overall, I think, is when you have an incident, number one, make sure you're aware of what your timing requirements are for notification. And you will have an obligation directly to the payment brands to tell them about an incident. Now, one of the things that please go ahead, Carmen.
One more.
Yeah.
Sorry. We have one of the attendees today works very, very closely with the PCI Security Standards Council, and he just wanted to add that there is an updated document on the PCI Council website about what to do in the event of a data breach. But having said that, if you have the Visa version, that will also suffice as good guidance as well. And as you just pointed out, MasterCard. So we just wanted to let everybody know that there's some updated documentation on the PCI website as well. So thanks for that.
No, thank you for adding that. Very great point. There's a lot of good guidance. And the payment brands have been good about, providing guidance on how to respond to an incident. It's definitely worth a read, preferably in advance of an incident, because it can really help you design your incident response program and timely respond and comply with their requirements. So, definitely worth the read to look, definitely worth the effort to go look at that, incorporate it into your incident response plan and be ready. One of the things that brands are increasingly requiring is to hire what's called a PCI forensic investigator. There are entities who are approved to be PFIs. And it used to be the requirement that the brands may, if there was a breach, ask you or actually require you to engage and hire a PFI. And the PFI is going to conduct their own forensic investigation of the incident. They will issue a PFI report. You may get an opportunity to comment on it. But it's essentially a report's going to talk about what happened and were there PCI compliance deficiencies. The thing to know is really, number one, I would point out there are very short time frames to engage one. For Visa, it's at their discretion whether you have to hire a PFI. And the requirements say that you've got a contract with the PFI within 5 days, 5 business days. MasterCard, it's now a requirement. So this is important. If you have a breach, MasterCard says you have to now engage a PFI, and that person, or that rather the PFI, has to be engaged within 72 hours. My suggestion is go get one now. Have one on retainer. Have one ready to go. In the middle of a breach, it's chaos, and you don't have the time then to go out, look for one, find one, engage with one, get it done now. This is just something you don't want to have to deal with. Important from a legal perspective, what they do is not a part of a privileged investigation. You cannot have counsel hire the PFI and shield their work product, including the PFI report, under the attorney-client privilege. It is not. It will not be a privileged investigation. A number of companies will hire their own investigators under the attorney-client privilege to work in parallel with the PFI's investigation. This can be helpful because what they determine, what they reveal, will be under the privilege, but the PFI's conclusions and findings will not. This can be particularly important if you're anticipating litigation or a governmental investigation. You want to have their own independent assessment. You want to be able to protect what they do for you, because the scope of what they look for may be more PCI related. If a breach is bigger than just credit card data or payment card data, that's where your independent investigation may go broader than a PFI's review. So, engage a PFI now. Know that it's not privileged.
We had a couple more questions come in, Todd, and relative to skimmers found in a fuel dispenser. And I know for, at least as far as I knew, I thought that skimmers were exempt because it was still considered a fraud issue, and more or less that the convenience store owner was sort of the victim, so to speak. But how does that play into all of this, the skimmer?
So if someone is, so if someone has put a mechanical device on top of a skimmer at the pump, for example, which is the most common scenario, right? They're still able to obtain payment card data. I imagine that would still trigger notification, maybe a PFI. So I think that's going to be my initial reaction. I'd want to look more into it. My initial reaction is I think that's going to be like very similar to any kind of other credit card or payment card related breach. In terms of liability, I'd want to think more about that, honestly, in terms of whether it's marketer or the parent, the franchisor's liability, and that's going to get into contractual issues between the marketer and the franchisor, the parent entity. So it's going to be heavily contractual. You will still have payment card obligations. Car, is that going in the direction, or is that answering the question?
Yeah, a little bit, and we've gotten some more clarification that's been coming through, and based on the audience here, the general thought is that a skimmer does not necessarily indicate that there was a compromise of data, but that there was just some fraudulent activity, and so therefore that's when you get the police involved, the FBI or Secret Service, so that they can help find the ring that is indeed placing these folks in there and finding the skimmers.
I like reaching out to law enforcement. And often I do. It's a case-by-case assessment, whether you do or whether you don't. One of the things that the FBI has been particularly helpful, at least in terms of the incidents I've been involved in, is to your point, Cara, they often have knowledge about the different bad actors, the threat groups that are behind these various attacks. They can be helpful. What else, Cara? I'm sorry.
Yep, no, that's fine. So another question is, where can you find a PFI? And so that is on the PCI Security Standards website if you need a PFI. And then also, if I remember correctly, and another person here verified that your PFI cannot be your QSA. As a matter of fact, I believe the guidance is that your PFI, or your PCI PFI cannot have done any work for you for the last 3 years, whether it's your scanning or your penetration testing or even your QSA. So they're pretty strict on those types of things.
Yeah, absolutely. All great points.
So that was it. Thank you. And we'll try and get back with the folks that asked about the skimmer, but I'm almost certain that it is considered more of a fraud issue than a data breach issue. But then I'm not an attorney, so we'll follow up on that.
Next, one of the complications that affects this industry in particular is that sometimes the breach, the incident, it really doesn't, it involves a merchant or a franchisee or a marketer. And one of the quick questions is, well, who has the liability? Who has the obligation to notify? Who has what role and responsibility? One of the first questions from a PCI perspective is, well, who's the merchant of record? Is it the marketer, franchisee, or wholesaler? Or is it more the franchisor? That in many ways determines who has an initial reporting obligation vis-a-vis the brands and the acquirer and processor. And other issues that come up, well, who has a notification obligation? I just mentioned the merchant of record, but from a state perspective, it may be a different analysis, because in a way it's the customer of the franchisee, maybe. And so there's a different notification analysis you have to undertake from a state level notification obligation review. You also need to look at your contracts. Maybe that contract between you and your franchisee says who's going to notify. And if it doesn't, that may be one thing you want to address proactively to not have to go through this analysis later on. Other issues that arise with this complication, if you will, is who's going to take the responsibility. Is the franchisee going to are they going to indemnify for the breach if they're the cause of it, or if it relates to them? Once again, it's a contractual issue. And of course, the overall brand impact. If it's a breach which is potentially large, and the franchisees are not going to be able to stand behind it, the indemnity is not going to be of much help. And if the breach is going to affect the overall entity more than just the marketer, that's where the parent or franchisor wants to step in, lead the investigation maybe, and really just own the incident, if you will, because it wants to make sure it's done right. It mitigates and limits any brand impact, and it limits the overall damages and costs incurred with the breach, knowing that the franchisee may not be able to cover all of those losses. So, obviously, if there's a breach affecting a franchisee, wholesaler, marketer, you want to be mindful of who has the obligations, what the potential exposure is, and that'll in many ways dictate and lead how you're handling the breach response. What about service providers? Another issue we're increasingly seeing is a lot of the bad actors out there are not necessarily targeting the main entity, but they're going after the service providers. And of course, one of the most well-known ones out there was Target, and it's been reported that the incident the initial point of intrusion was at the HVAC vendor. But that is representative of a trend we are increasingly seeing, where it is a vendor or a service provider is the point of intrusion or the point of the breach. And Cara, to your point earlier, what happens if you outsource this? Well, this is where this entity this issue often comes up. One first thing to quickly appreciate, and you'd expect this, which are the interests of you and your service provider or vendor are going to diverge. If they're having an incident, it's possible, or maybe even likely, that it's affecting multiple of their customers. So from a pragmatic perspective, they kind of have to limit what they report out and how much they coordinate, because they need to address it. They need to contain it. They need to remediate it. If they have other customers coming into their environment or interfering with their investigation, that can create issues. Flip side is, if you're the merchant of record, or if you're the one who's going to be holding the liability at the end of the day, you have to investigate. You have to ask what's going on. You want to be involved. So there is that kind of inherent tension where you have outsourced or subcontracted various parts of your CDE or other systems to a third party. There is that kind of inherent tension there. Some of these things can be addressed contractually. One of the first things is you want to know about the incident. So this is where that contractual obligation comes, where if you have an incident and if those of you involved in contractual obligations know, there's a lot of haggling over exactly what the trigger is for when the service provider is going to notify you, or whether you have to notify them. Honestly, I've seen a lot of service providers who have, I've got a contractual obligation, but I'm more interested in containing this. I'm just not going to comply with that contractual obligation. That happens. So sometimes just be mindful that sometimes no matter what your notification trigger is, 24 hours, immediate, whatever, they may not comply with that. And frankly, they may not if they suspect that. Well, they may not know if it's an incident. They may not know the severity of the incident. They may not know if it affects you. They're going to err more likely than not on the side of not notifying you because, well, they want to be certain about what they know before they go out to the public. Then there's the liability. This comes up in indemnities, exclusions from liability limitations, and the like. Audit rights, to what extent customers can get involved. Information sharing, how much they have to share with you. Are they going to share IOCs, their remediation plan? What are they going to share with you? And of course, the overall notification obligations to the public or to the PFIs or others. I'm sorry, the payment brands or others. So, not just when they're notifying you, but as between you and the service provider, who's going to take on that role and responsibility to go out to the public and issue the relevant notifications to them. These are all things you want to be thinking about in your contracts with your service providers. And, there's challenges both ways that you have to recognize going in because it can be multiple customers who are affected. And I mentioned this earlier, but notice that some laws impose obligations directly on vendors. So no matter what you say, there may be a law that overrides what you require in terms of maybe you tell your service provider, we don't want you to tell in the public. Well, it may be they have a legal obligation where they have to do that. And you just need to be aware of that potential obligation. Breaches cost a lot. We've all seen the figures out there, millions of dollars for breaches. They can be big. It's the brand impact, which is the hardest thing. You really can't quantify the brand impact. And this can really be detrimental to the reputation and whether companies go or consumers go to you. We're seeing surveys. There's one yesterday that talks about how privacy is impacting consumer choice. Obviously getting in front of this from a communications perspective is key. The best situations are where you're the ones who are leading the public dialogue and the narrative about what the breach is about. If others are out there, if Krebs breach beats you to this, or others out there telling the story, it's hard to reverse course in that. So it is always that delicate dance. Do we go forward publicly or do we hold back? If we let someone else beat us to the story and scoop us, that could be problematic. One thing we've seen is a lot of good PR firms who are really on top of this space. They know this. They work with reporters. We've had PR firms work with reporters to hold back stories so that we could do certain things to get us in a better spot before it went public. So that can be a good consideration. Increasingly, we're seeing breaches outed on social media. So if you suspect you have an incident, immediately start monitoring social media, blogs, Brian Krebs, of course. So be looking for that. Anticipate that employees will talk, or anyone else for that matter. I mean, if you go forward and tell your service providers or others, you kind of have to take a kind of a position that it's out there and kind of act accordingly, just knowing that confidentiality is really hard to maintain. You want to limit third-party disclosures, and by all means, make sure all your communications are consistent. You don't want to be telling one party X and another party Y. That will come back. Real quick, what happens after a breach? The PFI is going to issue their report. The brands, depending upon what the findings were, the causes, whether it's non-compliance issues, they issue fines, fraud recovery, and the like. There may be regulatory investigations. We're seeing certain state AGs are becoming more frequently the people who send out requests for more information. North Carolina, New York, Illinois. There's a variety of them. I think Indiana maybe. There are certain AGs that are more typically seen as following up on breaches after you send out that notification. Civil litigation is really common. I mentioned already that one. His name is Jay Edelson. He's got a very well-known plaintiff's attorney. He's very good. He's got a Gulfstream jet, I understand, just from these types of claims. We're seeing issuer claims, shareholder derivative suits, contract claims. There's seemingly an increasing list of types of litigation claims that are arising. For those of you who have been enjoying CCPA compliance, CCPA now has a private right of action for breaches, including statutory damages, which really is a game changer, just because the size of those statutory damages make breaches in terms of settlement values much larger. I think it's $100 to $750 per record. typically in settlements, the average multiplier was about $1.50 per record. When your starting point is $100 statutory damages under California, plaintiffs' attorneys are much less amenable, or we anticipate they will increasingly be, to those lower settlement values. So, that's obviously something that people are keeping top of mind right now. And just to add to that, the cost of an investigation can be pretty high. Counsel, PR, forensics, and things of that nature. Containment remediation cost. You're going to find issues. You're going to find misconfigured servers and user accounts that had access to multiple systems or were shared accounts. There's going to be a bunch of things you want to fix, and that's going to take time and take internal resources, external resources, new tools, money. Notification cost. If you have to send out 1 million mailings, that can be several $1 million just to send out a mailing. Regulatory, payment brand investigations and costs, litigation costs, it all adds up. So these things are, these are big dollar affairs, as we've all seen so far. So what else do they tell you? Many of you may have heard a lot of what I've already said before, but I gave some thought to, what is it that people don't tell you about breach response? You read these texts and NIST, all these other guidance out there, but what are they not telling you, what's not in there? The first one I see is breach fatigue. You got a breach, there's this kind of euphoria, everyone's excited, it's a breach, it's a sexy thing, but it wears out quick. Management gets bored with it, they're ready to move on, they don't want to deal it. It's just bad PR, they don't want to have to deal with that anymore. And give it a week or two, they're ready to move on. So you've got a limited period of time to really do what you need to do, set the stage, set a plan in place, and just knowing that management and employees will get tired of this very quickly, and you got to anticipate that. Information will leak. Things are going to get out there, and things are going to get out there like, where in the world did they hear that? I had a breach years ago, and people were saying, oh, it's a Dominican street gang, and it was not. It was some well-known, Russian group or something. But information is going to get out there. Some of it might even be right, but you got to plan on that as a part of your incident response and your communications. You're going to get a lot of frequent and tricky questions. Your marketing and communications people are going to push you. Is it contained? Can we say we're done? That there's no more threat to consumers and all that. And you're not going to necessarily be able to give a binary statement. Yes, we are, or no, we're not. It's going to be degrees of confidence, and that's just something you got to anticipate as you go throughout one of these things. Another is when to end the investigation. The more you uncover things, you may uncover stuff from other incidents, frankly. So there's a bit of an art to determining when have we looked enough, when have we turned enough stones over, when have we reviewed enough logs, when do we call an end to this thing? And that's going to be a challenge at some point for a number of these breaches. Documents, emails, reports, you got to worry about discoverability, privilege, and all those things. Working with law enforcement can be a challenge. Recently they're mindful and they know that, there's a lot of pushback from companies to collaborate with them because in the past, they haven't always been forthcoming with evidence, and frankly, sometimes they'll come in and walk in with subpoenas demanding information, and that just interrupts an investigation response. But they're getting better, but it's just a delicate dance. You just need to be thinking about if you're going to go forward and talking with them. And then, of course, confirming vulnerability remediation, knowing that, if there is a certain system patch that hadn't been timely pushed down and now it's a point of intrusion, or maybe it's even your service provider, and they've got a vulnerability, making sure that they've fixed it. Whatever you do, it would be advisable to make sure that whatever that point of intrusion, whatever led to the incident, see what you can do to, to minimize, or even, reduce or remove that vulnerability. Obviously phishing emails, those are around. We can only do so much. But, other things like, unpatched systems, those have got to be fixed, because the worst scenario, not the worst, but a bad one, would be, you have two successive breaches, both through the same vulnerability or system or the like. So, and the second one, regulators are going to come back much harder on you. And certainly from a litigation perspective, it puts you in a worse position trying to defend that claim. So this is the last slide. These are just some takeaways we came up with. Engage a PFI now. Make sure you got external counsel ready to go. Know them, or talk with them. Have them come in, talk with you about what their capabilities are. Have they done a lot of breaches in your space? Ask them specifically, have they done PCI related breaches? If it's people, we've done a lot of HIPAA breaches, that's not going to be helpful for you. Make sure they know PCI DSS, the brands, the whole PFI process, all of that, very important. And there's a lot of lawyers out there who've done a lot of that, and it's key to what you guys do in your industry. Review your incident response plan, maybe update it. Kick its tires, make sure it's still relevant, it's right, you got the right CCERT identified, you've got after hours, cell phones for people. These things always happen. A lot of them happen on, Friday after Thanksgiving or holiday weekends. Saturday night and Sunday morning seems the most frequent time. That's when they seem to trigger up the ransomware. Do tabletops, including with your management. Know your CCERT, check logging and retention. And that also happens to be a PCI requirement. Check your key vendor contracts, review your cyber liability insurance. Not all cyber liabilities are the same. Make sure your policy includes for recovery of PCI fraud recovery, fines, and has other recovery, and doesn't include exclusions for things that you're most likely to incur in connection with a breach. Identify your notification requirements, but know that they're going to change. That's a very fluid area right now, especially on the PCI front. See who's got an FBI or a Secret Service contact. Those are relationships, if you have a good relationship, that can greatly improve how much assistance they're going to have and whether they become a hindrance during your investigation response. Map your data. Most frequent issue we see is systems are affected and no one has any idea what data is on those systems. That's a common issue. And if you can map your data now, you may have done some of that in connection with your CCPA compliance project. It'd be great if you did. But know what data is on your systems. And of course, with the CMDB, know what systems you've got. How are they configured? What software are we running on those systems? Where are they connected to? Which systems connect with what? What are the access controls? All that stuff should be in your CMDB or some form of a system or architectural map for your environment. And of course, engage future vendor contracts expecting a breach. We walked through a second ago some of the different things you want to be, have addressed in your contract. So on a going forward basis, have a role in that if you can. Cara, that's the end. I'd love to hear any questions folks may have.
Yes, Todd, thank you so much. I think that was a lot of great information, and I think it's one of the first times we've heard about data breach responses from an attorney's perspective. So we appreciate you sharing your expertise with us today.
My pleasure.
One of the comments came in back to the skimming discussion that we had is there was a comment here that said skimming usually, quote unquote, falls off the data breach table just due to the volume of cards at risk. Basically, not so many in a skimming event where cards are acquired at one time, right? So there's not a whole lot acquired, and it's one by one, versus breaches of the POS system, which will definitely net more for that attacker. And breaches of a POS system can lead to a qualifying event. I think that breaches at an aggregation point, such as in home office, even in the environment that we're in today, could possibly even be game over. So thanks for that. Another skimmer-related question was, is finding a skimmer in a dispenser considered a breach? And if yes, does this change depending on the state where the incident occurred? And I think it's more along the lines of notification, and there are certainly different skimmer laws on a state-by-state basis. So we definitely encourage you to check with your state and where you operate, just to make sure that to determine whether a skimmer is identified as a data breach event or not, or if it's just a criminal act, and what your notification requirements are. So one of the other questions was, with the data breach litigation, is quote unquote standing still an issue that deters attorneys from pursuing legal action on behalf of the consumers?
Fantastic question. There was a case that the name escapes me at my moment, but it got up to the Supreme Court on the standing issue. It was remanded down to the Ninth Circuit. The issue is, to sue in federal court, you have to have standing. You have to have an injury in fact and a concrete injury. And the question is, just because your personal data has gotten into the wrong hands, have you been injured? I mean, what is your injury? What is your injury in fact? And this is where we're seeing a lot of the different federal circuit courts vary. There's two different groups in terms of, to what degree of a breach affecting your personal data do you or do you not have standing. On the one end of the spectrum, you have, let's say the lost or stolen laptop, where you just happen to lose a laptop, maybe it's even encrypted. What's the likelihood a person whose data was on that lost or stolen laptop were injured? On the other end of the spectrum, you've got people whose credit card data was stolen. There was some identity theft using those cards that were in the stolen population. Maybe people charged stuff to their card. Accounts were opened up in their name. So that kind of represents the spectrum. And I think I don't think I've seen a court yet that has not upheld standing in that second category, where you can show some form of identity theft or other kind of damage to you. On the other hand, on the first category, there's some variance in the courts, but the challenge there is it's speculative whether or not you've been injured. So the more you increase the degree of speculation that you had any kind of provable harm, the more speculation, the lower the chance you have standing. In terms of, are we seeing it reduce, the number of cases filed? Not so much just where they're filed, because what the plaintiffs are going to do, they're going to go to those courts that are more likely to find standing, and that's where they bring the claims. They're also targeting certain jurisdictions that have what we call rocket dockets, meaning that from between the time of filing the case and when you try the case, rocket dockets are those that have that shorter period of time. The well-known jurisdictions are going to be, I think, was it like the Eastern District of Texas, I think, Eastern District of Virginia, or there's one, it's Southern District of Florida down in Miami. Those are the kind of the three most common jurisdictions, I think. And that's where we're seeing a lot of cases filed. Although with Virginia, it's in one of those circuits, I think, that is less likely to find standing. So we're not seeing as many cases filed there. Now, with CCPA, that too is going to trigger a lot of litigation in that state. And that's the Ninth Circuit has been among the more generous in granting standing. So that's where we're seeing a lot of cases in large part because people want statutory damages available under CCPA. So yeah, not necessarily limiting where cases are being filed, or not limiting the filing of cases, but just limiting where they're filed. And certainly when people file their lawsuits, they bolster facts to the extent they can that show some kind of harm to the person. In your industry, though, I mean, when a credit card data is stolen, that falls on that end of the spectrum where it is more provable to show that there is harm. I mean, kind of the reverse question is the case, which is if they didn't intend to steal a card to do identity theft or charge money on people's cards, why else would they have done it? So, that's where we're seeing a lot of cases, and they're withstanding some of those early standing challenges.
Thanks, Todd. We have one last question, and then we'll wrap it up today. And it's just beyond the PCI data, do you have any recommendations around corporate data and corporate financial information? Again, beyond PCI, do you have any recommendations around corporate and corporate financial?
Yeah, so that different types of data have different degrees of value to bad actors. Financial data, we've seen hacks where people would, see what the financial performance of a company is and either short or whatever the stock. I saw a breach years ago where the bad actors had actually shorted the stock, and then they timed the acquisition of the shorts on, making a big disclosure and triggering a large attack on the company, anticipating the stocks company would go down. So yeah, financial data is very important. And now it's, financial data may not be personal data, in which case it may not trigger notification obligations under, various state laws or even PCI. But it still can be very impactful. Other data that we're seeing that has value is, of course, intellectual property. So source code to products, for example, that has a lot of value. And there's different threat groups who go after these different data types. I won't get into that.
Right.
But, certainly financial data, healthcare data, intellectual property, employee data can have a lot of value. Over the years, we've seen a lot of attacks. We saw those, W-2 attacks where you get that phishing email or spoofing email sent to the CFO or a controller of a company saying, "Hey, send me a PDF of all our employee W-2s." And they did, and then they went ahead and these hackers went about and we saw a rash of this for a while. They had filed tax returns trying to get the tax refunds from employees. So that was popular for a while. We saw a lot of these 401k breaches where people would compromise email accounts, change credentials to a 401k, get into the 401k, and then drain the employees' 401ks. those were popular for a while. So yeah, there's a lot of different types of data sets that have different types of value that need to be protected. And certainly with the statutory damages available now under CCPA, any of the data types that trigger those, which is usually a person's name plus social, DOB, financial account, health data, that kind of stuff. Usually the same type of data that triggers a notification obligation. That's what triggers some type of a statutory damage, and that's what needs to be put under perhaps enhanced security controls.
Not only that, but I think we're seeing in our industry a lot of loyalty data breaches, and so that seems to be ramping up significantly. The other thing too is so that people are so focused in their convenience stores of securing the payment card data, but they forget about loyalty. We see a lot of programs where they're sending transactional information in the clear, and so you need to make sure that you've got that information secure as well. Conversely, also in our industry, we're seeing a huge ramp up of that marketer main office. So if you've got a branded wholesaler or a marketer or a small retailer that has like maybe 100 sites, maybe they're multi-branded, they have networking out to the different locations from just from a sales data perspective. But the threat actors would sometimes, if they can't connect to from that main office, if they can't connect to those point of sales like they think they can, that's when they shut you down a ransomware. So it's financial gain one way or the other, it seems.
Great thought. We're seeing payment apps and other things like that being the target of bad actors. So yeah, no, great thought on that one.
Right. So, well, thank you everybody for joining us today. And Todd, thank you again for sharing all of this great information with us. We certainly appreciate it. And
thanks for having me.
And so again, if you complete the survey that you get here in about an hour, and you complete the survey, you'll get a link to this presentation, and Todd's information, contact information is in there as well if you'd like to chat with him. So thanks again, everybody, and have a great day.